That appears to have worked.
Surely did.
Says we're being live streamed.
Okay, so you are live now, and we can talk about what happened later.
Thank you. Uh-oh.
Uh-oh.
There's still
Me
two of
mute.
you.
You just be
No one there?
Ah, now there's one.
All right, here. Let's see here. Can everyone hear me?
Two of you, Delegate Holmes, because I logged in as you basically, but somehow I got it to go live, so you're good.
All right. Thank you. Thank you, thank you, thank you. All right, now what's wrong with the camera? Okay, so good thing I can land an airplane better than I can work this daggone thing. Maybe not. Okay, here we go. All right, ladies and gentlemen, thank you for attending our Housing and Real Property Subcommittee meeting. As indicated earlier, this meeting is a workshop meeting, and we will be holding this meeting for discussion purposes only. We will not be voting on any bills on this particular meeting. Next meetings, we will start our voting sessions. All of you have received the list of bills, and just for the record, the bills that we're going to be discussing will be HB 26, community managers, HB 40, which is disclosure of unit owners, prohibition, provisions, and instruments, HB 86, tenants' rights, HB 107, reserve studies, HB 117, evidence of insurance, HB 134, prohibition on rent increases, HB 140, which is governing bodies and annual meetings. Now, let us first start by going to HB 26. And HB 26, ladies and gentlemen, is a bill that is attempting to have community managers licensed. Now, some of you recall this bill from previous years, and I see that we have a hand up here. David Fraser Hidalgo.
Yeah, just I had a quick question. Are there other, I know we've had this bill in, over the years, and there was some folks that had some concerns about it. But one of the questions that I had in regard to that is, do you know what other states there's, as I recall from the testimony, there were a significant number of other states that do this already. Is that true?
There were states that had, there were other states that have done it, yes.
Okay.
You heard testimony where two states had just recently taken off of their legislative docket. And Matt, you want to take over? You had so your hand raised, Matt.
Yes, so I actually wanted to, just going back to the bills that would be heard today, given the timing of the meeting, there were a couple that I was not able to prepare for discussion in terms of looking at suggested amendments, HB 26 being one of them, HB 86 and HB 134. So I didn't know if you wanted to reserve those for the end and general discussion and focus on ones where there's been a more complete analysis.
You said 26, 86, and 134?
26, 86, and 134. The other ones have all been prepared. And I apologize, it was just a timing issue with the drafting deadline.
Okay. All right, we'll do that then. We'll
okay.
push those bills off until next week. One of the things that has been discussed, and I'd like for you, we'll talk about that later. So now, ladies and gentlemen, let's go to HB 40. And HB 40 is Delegate Watson's bill, and is in reference to condominiums, disclosure to unit owners, prohibited provisions and instruments. And what I will attempt to do here, ladies and gentlemen, is to look at this bill and pull it up. HB 40, just in case someone has any questions about it, we can kind of go through this bill while we're looking at it. Well, I can't do that because Trish took over as host. Technical glitches again. Anyway, Matthew, let's discuss this one and any suggested amendments that you may have to this or amendments that you think might be forthcoming. Matthew?
Sure. So as the subcommittee may recall, this is the bill that clarifies that a board of directors of a condominium may not withhold or agree to withhold from the unit owners the terms of any legal agreements to which the council of unit owners is a party, and also alters the circumstances under which provisions within specified instruments regarding the settlement of disputed claims are unenforceable. So it's identical to a bill that the committee passed in 2020. It was unanimous amongst those present in the committee, and it passed the House on third reader by a vote of 137-0. So what's been introduced here is that third reader version. There were no unfavorables in terms of the testimony. There's one group that testified favorable with amendment, and that was the Maryland Building Industry Association. There wasn't any particular recommended language, but based on the testimony, looks like the recommendation would be to strike language making any provision in an agreement that prohibits disclosure of any term of this agreement to the unit owners. It would strike the purchaser language for the subsequent sale, a secondary sale from a purchaser to another private party. And let me just do.
What part of the bill is that, Matthew?
That is, sorry, let me pull the language of the bill up. That would be on page 3 and in line 19, the or to a purchaser under 11-135 of this title, basically from the comma to the comma in line 20.
Okay, and so what did they want to do?
Well, again, there was no particular language that was provided. Just based on the testimony that was provided, it would strike the applicability of this paragraph to the enforceability of a non-disclosure agreement with regard to a secondary purchaser. So
okay.
whereas this new language would say, except in the case of an agreement related to a personnel matter or an individual owner, any provision in an agreement that prohibits disclosure of a term of the agreement to the unit owners is unenforceable. They would want that to only apply to a provision that says you can't disclose to the unit owners.
Okay, let me go
and not
to
a secondary purchaser. They want to remove the secondary purchaser component.
All right, let me go to Delegate Terrassa and then to Delegate Lehman.
Thank you, Mr. Chairman. As I recall the discussion, that would defeat the purpose of the bill. I mean, it is that type of disclosure that this is seeking to have. And we approved of this way last year. So I don't think it would make any sense to amend that way.
So you're saying that deleting that, Delegate Terrassa, would delete the purpose of the bill is what you're suggesting, is that correct?
Right.
Okay.
And would cause problems for the sale of property because you could have known problems that you can't disclose.
Okay. And I'm highlighting this section for my own particular, are you completed, Delegate Terrassa?
Yes, thank you.
All right, Delegate Lehman.
Okay, thank you. Delegate Terrassa's question actually helped me a little bit, but I wanted some sense of what kind of disclosure we were talking about. I was assuming it was financial. She referenced problems maybe with the property. I also don't understand how personnel matters relate to this. That provision kind of threw me off. Can anybody, Matt, or can you explain?
The lead-in is except in the case of an agreement related to a personnel matter or an individual owner assessment account. So if there were a provision in some agreement that prohibits disclosure of any term of that agreement, and that agreement dealt with a personnel matter or an individual owner assessment account, that non-disclosure agreement would be enforceable.
Would not be enforceable.
No, would be
Would
enforceable.
be.
Would
With
be,
regards
would
to
be.
personnel matters and a matter pertaining to an individual owner assessment account. If it wasn't one
Okay.
of those two things, the NDA would be unenforceable.
Okay, I misread that, but let me go back to what other kind of disclosure would we be talking about? Can someone give me some examples of, is it primarily financial? What other, I don't recall Delegate Watson's testimony, what she emphasized in the way of disclosure, and it's just so vaguely written. And I certainly don't recall the bill from last year. So could you help us with that?
So it's the language here, this particular language we're referring to is, sorry, one.
This came from the Sunset Island issue.
Matt,
Sorry
Matt, you're on,
about that.
yeah, go ahead, Matt. And you're on mute. Go ahead, Matt.
No, sorry about that. Pardon the interruption. So there was any provision in an agreement that prohibits disclosure of any term of the agreement. So basically with regard to anything that creates a non-disclosure agreement.
Is
Could
it
be a-
okay? Is it
could be a
intentional that
settled-
is it intentional that it's written this broadly? It's hard for me to tell what the bill is even trying to get at. I mean, I don't, is it okay, Mr. Chairman, to ask Delegate Terraza only because she's a co-sponsor of the bill and maybe would have some, I just am not remembering this at all from last year. And the way the bill is written, it sounds like it could mean anything, but maybe that's intentional.
Delegate Terraza?
Yeah, I don't know if Karen Strawn might have more information on this, but I believe this came out of the Sunset Island community and there were deficiencies in the building and the board signed off on those. I'm trying to really read quickly. I know Cindy Ardinger testified on it. Does Karen Strawn, do you have
Yeah,
information about that?
Karen?
Yes.
Okay, thanks.
Yes. Thank you, Delegate. The problem was that there was some deficiencies in the building that was resulting in, I believe it was balconies and hand railings and things like that were falling apart. And in order to fix it, they were required to enter into a agreement where they would not disclose the information about what the problems were that were causing everything to happen. And so they could not disclose to the unit owners and they could not disclose to prospective property owners who were looking to purchase. So they were ending up having all these problems, making an agreement to get it fixed. And later on, there were additional problems that none of the unit owners knew anything about the original agreement, which then prevented them from being able to do anything later on.
Thank you. Thank you so much. That is so helpful, Ms. Strawn. I really appreciate that. Thank you, Mr. Chairman.
Sure. Jen, you got another question? I see your hand still raised.
I'm just saying, like, that is the very problem this is trying to address. So that is why I wouldn't want to take out that provision. But thank you. Thank you, Ms. Strong, for explaining that. Reminding.
Delegate Healy?
Thank you, Mr. Chairman, and thank you, everyone. I wanted to try to since we didn't see any amendment language, I saw that on the testimony, the builders and the bankers wanted an amendment, but it isn't clear to me what the parameters of that amendment might be. Maybe we could ask one of them to explain exactly what they want amended in this bill, because I do think that the bill itself is needed. I don't think that if you're a property owner and the board makes a deal with somebody for a non-disclosure and the owner who employs them doesn't have access to what the deal was, that doesn't seem right to me at all. So I want to understand what kind of amendment we're talking about.
Okay. Well, let me then go to Mr. Hinton, who is a representative for the banking industry and the home builders. Mr. Hinton, do you want to expand upon the requested amendment and how that fits into all this? And number two, is there a written amendment that's been proposed?
So, Mr. Chairman, we didn't have a specific amendment at the time of the bill hearing. This bill came up very early. I think it was the second day of the session. And we have met and had a very a long meeting with the sponsor and with the constituent that brought the bill to her. We are working on amendments with them and would hope that we could at least hold this bill because until we can get the amendments wrapped up with the sponsor and with her constituent. The concern that the builders, is not, by the way, it's not the bankers, it's just the builders that I represent on this issue. Concern with the builders is that we didn't think the language was clear, that what you are disclosing is what the bill deals with is to make a non-disclosure provision in an agreement, not the agreement, but the way the bill was drafted, the non-disclosure provision in the agreement, unenforceable as to the unit owners. And frankly, we're working on that language. We don't have a problem with that concept. We just haven't worked the language out yet with the sponsor and with the constituent that brought it to her. Typically what happens is if there's a dispute between the developer and a contractor, and that goes to the board of directors, enters into, the dispute between the builder and the board, and they enter into an agreement, the board would disclose the terms of that agreement to the unit owners. And the concern was, well, there's a provision that says they can't. We don't have any problem with the terms of the agreement being disclosed to the board, and I guess, and to the unit holders. We always assume that the board, acts on behalf of the unit owners. So we're working on the language. I feel confident that we will work it out with the sponsor in a fashion that addresses the concerns that we have. And frankly, one of the concerns is it's one thing to give it, to have the agreement disclosed to the current unit owners. But, you're going to 3 or 4 years down the road, whatever, it's all been settled. There've been no problems, but now you're going to raise a flag for every prospective purchaser that they're going to see that there was this claim or this suit or this dispute that was the subject of a settlement agreement. And we don't think that's in the best interest of the contract of the owners, because it's going to put a cloud on their ability to sell the property. So we're trying to work through all that. We ask you to give us another week to get through it.
All right, let me go to the sponsor, and then I'll go to Lisa Harris-Jones. Delegate Terrasa?
To be clear, I'm not the sponsor, it's Delegate Watson, but.
Oh, wait, I'm sorry. I'm sorry, you are correct. Watson's the sponsor. I'm sorry.
Okay, I do want to say something, but I will wait my turn.
Okay, thank you. Let me go to Lisa Harris-Jones, and then back to you, Delegate Terrasa.
Sure. I just wanted to point out that this isn't a new bill. It did pass out of committee, and you're accurate, Karen, and those that pointed out that this came out of an issue. I think it was sunset. The original bill actually had the title, the name of the community in the title of the bill, I believe, from a couple years ago. But the amendment, if I'm listening to from listening to the hearing and Mr. Hinton, the amendment that it sounds like they're suggesting would just completely gut the purpose of the bill.
Absolutely not. Absolutely not.
Hey, Mr. Hinton, hang on, please. Lisa Harris-Jones has the floor. Go ahead, Ms. Jones.
Thank you for that, Delegate Holmes. But yeah, I believe that it would gut the bill. And it's a bill that's been before this subcommittee before. It's been discussed, it's been debated, and it passed out. And just some of the comments about, the board of the HOA or COC, that you can't, that's the whole point. You can't assume that what the board knows is being shared with the unit owner. And the whole point of this bill is to make sure that the secondary purchaser knows of a deficiency or problem that occurred with the unit or the property. So I would prefer that the bill stay within the form that it's in, because that's something we discussed, not new. I'm surprised that your amendments prepared, because it's not a new bill. It's been seen before, but that would be the position of CAI.
Let me go to Delegate Trassa, and then I'll come to Mr. Hinton.
Yeah, I couldn't agree more. And I mean, I think the problem is, once you know there's some kind of defect in the building or in your unit, what have you, and you don't report that to the subsequent owner, you have that's a fraud anyway. I guess the problem is, it sounds like you want to be able to have these non-disclosure agreements, and I'm not sure they're appropriate in these situations anyway. There are large communities that are affected by these, or medium size or whatever size communities that are affected by an agreement. So you might have, I'm just thinking of like a piping issue or a roofing issue, where perhaps some of the units have the problem exposed right away, and some of them it takes a while before the problem shows itself. And just because there's a settlement agreement early on doesn't mean that others won't show soon after. And so I guess that's my concern, is that you're then going to sell it to subsequent owners without them even knowing this had been an issue, or knowing to take a closer look at that. I just think that is that poses a problem.
Thank you, Delegate Trassa. And Mr. Hinton, you indicated that you are working with the sponsor, Delegate Watson, for an amendment. Is that correct?
Yes,
And when do you expect to have that?
I would say we'll have it by the time you meet again next week.
Okay. All right. Ms. Strawn?
Yes, I would just point out to the committee that one of the reasons it's important to be able to share this with prospective members is the resale package has to include that information. And if you are being told on one side, you have to provide it through a resale package, but on another side, you can't provide it because it's got a no disclosure agreement in it, it's going to cause a real problem. And so for consistency alone, much less the fact that these prospective purchasers be aware of what has happened so that they can determine and make a reasonable purchase based on what knowledge they have about the community.
So the resale, if I could paraphrase what you're saying, Ms. Strawn, you're saying that the resale package would prohibit you from putting this information in there for the new prospective buyer. Is that correct?
No, the resale package says that you're supposed to put that information in there.
Yeah,
I
but Mr. Hinton, hang on a second. We're going to go one at a time. I do not want to have us over talking each other. Okay, hang on a second.
Sorry.
Let's let Ms. Strawn finish. So the resale package, which you're saying, Ms. Strawn, is that you could not put this information in the resale package for the new prospective buyer. Is that correct?
If you pass what he is requesting.
That's what I meant. That's what I meant. Yes.
Yes.
That's what I meant. Yeah. Okay.
Then that would be correct. But the law says the resale package is supposed to include that.
It's supposed to. That is correct. Yes. All right, Mr. Hinton.
I disagree. I don't think the requirements to make disclosures to prospective purchasers tells you that you have to detail whether or not there was a dispute and whether that dispute was settled and what the terms of the settlement are. Once again, we have no problem with not having a non-disclosure provision in the agreement not apply to the ability of the board to disclose the agreement to the owners. In talking with the sponsor and with her constituent that raised this issue, who was a resident at Sunset, I think they both acknowledged that at some point, that this could have a detrimental impact on the actual residents when they want to go sell their property. I'm not aware of other businesses that have to make this kind of disclosure, but we're hopefully going to work it all out and come back with an agreed upon bill.
All right. Well, I don't want to talk about. I appreciate the fact that you have an amendment coming. I don't want to get too deep into the woods discussing something we don't have in front of us just yet.
I agree.
So instead of us just waving our hands around and pointing at different things that we don't have, I think we should wait for the amendment so we can further address this issue, so we know exactly specifically what the words are, so we know what impact it's going to have on us once we have the words. All right.
Right.
All right. Unless there's any objection, ladies and gentlemen, I'm going to go on now to HB 107. And seeing no objection, fantastic. We're going to go on now to HB 107. HB 107. And Lisa and Bob, if you could do me a favor, because I can't control anything, if you could put your hands down, I'd appreciate it.
Yes, sir. I'm not used to that.
Yeah.
I will. Okay.
All right, and put yourself on mute too, if you don't mind.
Yes, sir. Yes, sir.
Because I can't control that either. HB 107, ladies and gentlemen, is a bill that we've had before us previously. And it is about reserve studies. And we've passed this bill previously. We've also passed this bill by 2 jurisdictions, Prince George's and Montgomery County. Matthew, if you could give us some additional information on HB 107 that you have at your that you have ready available, I'd appreciate it.
Sure. So when the prior version of this bill was considered last year, passed committee by a vote of 21-2, passed in this form on third reading by a vote of 95-38. I will say there's a couple amendments that were put forward. There's one that I think is a technical correction that even if no other amendments were adopted or recommended, should be included in this bill for consistency. So on page 10 in D3, Roman numeral 2.
Hang on a second. Hang on a second. Let me get there and allow others to get there as well.
Sure.
Page 10. Okay, go ahead. Page 10 and what?
So page 10, subsection D, paragraph 3, Roman numeral 2. The date
what line
there,
number are you on? What line number are you on?
1 second. Pardon me. That would be line number 12. The date here, I believe, is supposed to be October 1, 2018. And then if you go down to lines 17 and 19, those dates should be October 1, 2018 and October 1, 2023, respectively. If you go to any of the other sections for the other types of common ownership communities, that's the date structure that's used in the Prince George's and Montgomery County bills for pre-existing common ownership communities that hadn't transitioned to owner control. There was a 1-year offset. So that for consistency's sake, homeowners associations should probably be similarly situated with condominiums and co-ops.
So the date, so you're saying then, let me look at, if the governing body of a homeowners association has had a reserve study conducted on or before October 1st, 2017, the government, but you're saying that should be in line 12, you're saying it should be 2018 is what you're suggesting.
Yes. So for example, if you look on page 7 of the bill with regards to condominiums,
yes.
Line 8 and line 13 on page 7.
Yes.
So I think it's a drafting error. This would be correcting a drafting error. So
Yes. I got you.
Mhm.
Okay.
So regardless,
Yes.
regardless of any other amendments that may be considered, if it's the subcommittee's recommendation to move the bill in its current form, there would at least need to be one amendment to correct that.
I agree. Now that I've looked at the condominium section, I understand what you're saying. It was just an oversight probably when the bill was drafted. Yes. Okay. Thank you, Matthew. Anything else you want to bring to our attention, Matthew?
Sure. Again, and I understand that this bill was heard early in the session, much like the last bill. There were two stakeholders that reached out. MBIA, again, the builders, proposed that the bill does not apply to a homeowners association that does not have recreational amenities and or private roads. There was an attempt in the last year to do something like this by creating the $10,000 cap on common elements for a homeowners association. So there's I guess some question there as to what an actual amendment that would accomplish the MBIA goal would look like. And then with regard to CAI, there were several recommendations. Again, there wasn't explicit language provided, but there were several recommendations. The first would be with regard to the requirement to fully fund the reserves, the believe that there would, or recommend that the payment be phased in over a 3-year period. And from what I see in the testimony, it would be the next 3 successive budget cycles after the reserve study was completed. So year 1 would require at least 80% funding. Year 2 would require 90% funding of the reserves, and year 3 would require the full 100% funding of the reserves. There was a second bit about affirmative enforcement, how this would be accomplished. And then in the third and final recommendation would be applicability to residential and non-residential condominiums.
Now you're talking about affirmative enforcement.
Mm-hmm.
I'm assuming that the testimony relevant to that particular statement is indicating that there's nothing in this legislation that specifically addresses enforcement. Am I interpreting that correctly?
Right. So the concern is, and Lisa Harris-Jones is here from CAI, who might be able to elaborate on this, but it appeared the concern was that how you would logistically meet the fully funding provision and confirm the status of a community being fully funded. It could be, and that the affirmative enforcement could be accomplished by including provisions in the legislation that would require a community association to furnish to some state agency copies of the reserve studies and the financials to show you have the 2 bits to say, this is what the reserve study said, and this is what we've accomplished.
Well, I'm sorry, I didn't want to cut you off, Matthew. You complete your thought there?
No, that was it. Well, I can clarify if need be.
Yeah, and we're going to come back to that, I'm sure. And Ms. Strawn, there you are right there. Now, affirmative enforcement. I do know that we've had this discussion about this particular issue numerous years. And if there's what I have purposely done is not put language in the legislation for affirmative enforcement, because there is already a methodology, as I understand it, for enforcement, but it's going to take someone within the community or board of directors, et cetera, to send a notice to your office for the enforcement to begin. Am I understanding that correctly, or is there something else that you can add to that thought pattern of affirmative enforcement?
Well, because it falls under the Maryland Condominium Act, the statutes provide that our office enforces the Condominium Act. So it does provide that there is enforcement authority through our office for this, should it pass.
And I guess what some of the comments have been previously is that some are suggesting that there is no oversight in terms of who has filed a reserve study and who has not. And because there's no oversight in looking at who has filed the reserve study versus who has not, then there is not a proactive enforcement. Now, for those of you who are not familiar with the Montgomery County CCOC, in Montgomery County, each common ownership community must disclose their reserve funding for their community. And once they disclose that they have funded their reserves, then the Montgomery County CCOC takes a look at the amount of reserves that have been funded versus the amount that they should have funded. That's the only jurisdiction that I'm aware of that has that type of proactive enforcement. Can you add something to that, Karen? This is another jurisdiction someplace?
No, that's my understanding as well. There is enforcement authority in the Prince George's County Reserve law statute But that is my understanding as well, that Montgomery County is the only one that does it proactively. We would do it in response to a complaint.
In response to a complaint. Okay. Let me go to some of the committee members first, and then we'll go to some of the stakeholders. And I think Delegate Healy had her hand up first.
Thank you very much, Mr. Chairman. Just a quick, try to clarify. I thought I understood this completely. Now I'm not sure. Is this bill requiring more than a study? Does it require you to have the study and then fund what is discovered by the study so that the money is actually put into the reserve?
That is correct.
It does require them to put the money in the reserve.
That is correct. Matthew, can you expand upon that, please?
No, that is correct. Let me see if I can pull up the language very quickly that points to that.
And in addition to that, Delegate Healy, once a reserve study is conducted, the way the language in the bill is structured, and I can't find the exact page and line number right now, the way the language in the bill is currently stated is that once a reserve study is done, the common ownership community must fund 100% of the reserves required.
Okay, so the study requires them to make the commitment, of financial commitment to address it.
That is correct.
Okay, thank you.
Matthew?
Yes, and just quickly, I was able to find the language with regard to cooperative housing corporations. Now, the way this bill has been created over the years, first with Prince George's County, then Montgomery County, and now in the statewide effort, is that a lot of the language was, where possible, just made consistent, although the placement may have changed given the act. So one place to look would be the top of page 5 in new subsection F. So from line 1 to 8, the governing body of a with regard to a cooperative housing corporation, governing body of a cooperative housing corporation shall provide funds to the reserve in accordance with the most recent reserve study and shall review the reserve study annually for accuracy. So the requirements to provide funds in accordance with the study.
So that answers your question, Delegate Healy, that
Yes,
they have to have a reserve study done and have it done every 5 years. And this bill says you have to have an updated study done every 5 years as opposed to a full study done, and it has to be funded. DFH?
Yeah, just a couple of questions, and I don't know if we went over it. The Montgomery County and the Prince George's County bills, were they local ordinances? Were they passed state law? Was it enabling legislation that enabled them to pass those?
It was local jurisdictions, both for Prince George's only. The first one was for Prince George's only. The second one was for Montgomery County only. The first one was Prince George's, and there was a statewide and a Prince George's moving forward simultaneously. Prince George's passed, the statewide didn't. And because the statewide bill did not pass, persons within Montgomery County were disappointed that the statewide bill did not pass. Therefore, they put their own bill together because they were wanting to make sure that something was going to be happening with Montgomery County, like Prince George's County. So they put their own bill forward, which got passed last year. So now there's only 2 jurisdictions that have it, Prince George's and Montgomery.
Right, but my question is, that was passed as a local delegation bill.
Yes, sir.
In the Maryland General Assembly.
That is correct, sir.
Thank you. Thank you.
All right, Delegate Terrassa?
Yeah, to be clear though, in terms of this, thank you, Mr. Chairman. So to be clear in terms of funding these reserve analyses right away, my understanding of how a reserve analysis is, and that is something I did when I was an HOA president, is that doesn't mean you put all of the money for every capital expense in all at once. A reserve analysis gives you a plan for how to fund those things over time. And so obviously, if you have something coming up really soon, you know, if you have to pay for something that's 30,000 over 3 years, that's 10,000 a year. But if it's 30,000 over 30 years, it's only 1,000 a year, right?
You are 100%. You are 100% correct, Delegate Terrassa. And I'm so glad that you expanded upon that definition of 100% funding. It does not mean like some people think. If a roof needs to be replaced and a roof is $250,000, that you need to put $250,000 in your account right now.
Right.
What that means is exactly like you said. You put the money into the reserve based upon the life of the lifespan of the component you're funding, to make sure that at the end of that lifespan, you have the money into the account. You are 100% Delegate Trust, and I appreciate you expanding that definition for us.
Which is the whole, right, thank you. And which is the whole point of having this analysis, because you probably, as homeowners, unless you're in this field, don't really know how to, or in some kind of accounting field, don't really know how to figure out the life of each of these items and to figure out how to plan it out over years. So that's one of the reasons I strongly support this. But the other thing, I just wanted to address this recreational amenities issue. And having been the president of my own HOA, small HOA, I should say, it was only 77 unit townhome. There's an awful lot of other things that a HOA pays for that can be a significant expense, including roads, including sidewalks, including retaining walls, including stormwater management, including your front signage. And those can add up quickly. And so I think, so if you don't have recreational amenities, you still may have a lot of expenses that if your community is responsible for paying them and you don't have a reserve analysis, will be a surprise special assessment on your residents if you don't have this reserve analysis. So I would urge us not to add that as an amendment.
Thank you, Delegate Trassa. Let me go now to Delegate Weigel.
Yes, thank you, Delegate Holmes. So question for you, I guess, how far out do these reserve studies go? So I could put a new roof on, this year, it's a 50-year life, and already I'm going to have to start a reserve fund for that roof going out the next 50 years. So is there a time limit on how far out these reserve studies go that would require funding in the reserve account?
I don't know the specific answer to that question. I can get a reserve study specialist on the line with us next week. However, I do know for a fact that if you specifically mentioned 50 years, the reserve study will indicate that that item that you're talking about has a 50-year lifespan. Right. In the reserve study, it will say this item has a 50-year lifespan. In order for you to fund that item in 50 years, you need to put $5 per year into your account. So at the end of 50 years, you have the money there for that 50-year lifespan item. Okay, $5, whatever it is. So that at the end of the lifespan of that item, the money is there.
So, I mean, everything in a building component eventually wears out. So is there, does this reserve study identify everything from the bricks and mortar to the patios, to the roofs, to the fascia, to the windows and all that someone has to estimate the remaining life on that and the replacement cost?
In a nutshell, yes. If you haven't seen a reserve study, I'll try to get one for us to look at next week. It is very, very detailed in terms of items in the common area, all items in the common area, right. Pavement in the parking lot. If you're talking about condominiums, it talks about the elevators.
Balconies.
Balconies, everything. So it is very detailed and is very specific to all the items that are in a common area and the lifespan of each and the amount of money will be required to pay at the end of that life cycle of that item.
So this bill basically assumes that special assessments are bad.
Two things. Hang on, DFH. Two things, Delegate Weibel. Special assessments in most cases are definitely bad. And I can give you some very specific examples to some very specific HOAs and condominiums in terms of special assessments being tacked onto their accounts, unit owners and lot owners' accounts in the tens of thousands of dollars, whereby those unit owners and lot owners have less than a year to put that money into their account. And if they don't, the condominium, the common area association does have the right to foreclose. This, and question number two, is this trying to circumvent special assessments? Yes. And I've used this analysis before about the old-fashioned oil commercials, filter oil commercials in the car. Either pay me now or you pay me later. I do not want to have our citizens in the state of Maryland having to come up with tens of thousands of dollars urgently when there's no need for it.
And I get that if we're talking about tens of thousands, but this bill also has no materiality threshold to it. So if we're talking about a couple $1,000s across whatever, a 20 unit association, it doesn't allow for that to be specially assessed. It has to be in the reserve study, the way I understand it.
That is correct. It does not allow for it to be special assessed. It does have to be in the reserve study. And in your particular example, if there's a, whatever you said, 20 unit building, 20 unit
Yeah.
HOA, then the reserve study amount would be minuscule.
Yeah, so would the special assessment. Thank you.
You're welcome. Delegate Terrassa, I have not forgotten you, Mr. Hinton. I want to get the subcommittee members first. Delegate Terrassa?
So that last question brought up to me, I guess I'm curious, I don't know if I can ask this question of Delegate Weibel, but I'm actually really curious. It sounds like you have experience with this, and I'm wondering what type of assessment, like when does that come up that it's that low? That there's, and it sounds like you do have that experience. So I'm actually really curious.
Well, actually, my experience is with a very small condo association who their policy is they want special assessments. They don't want a reserve study. And I've pointed out to them, or a reserve fund, and I've pointed out to them that that's probably not the correct way to go, that they should have at least somewhat of a reserve fund. So they've actually started to establish that. But there's a lot of minor stuff. You know, if you're replacing boards on a patio, or you're
okay, yeah.
if you're replacing fascia, or you know, or cosmetic stuff, ceilings in a garage, stuff like that. I mean, I don't see any reason why a condo association can't have the flexibility of deciding whether or not they want to fund that via a special assessment versus a, you know, it's reserve study and reserve fund.
Okay.
And you know, it's just a difference in philosophies, but it removes the flexibility of that association to determine how they want to fund.
Well, I appreciate
project.
that. My experience though is some of those things would be done in the operating budget as sort of.
Exactly. And I didn't want to cut you off, Delegate Weibel, I was going to hop in and say the
Well,
exact same thing.
ideally, yeah, this association doesn't have funds in their operating budget.
Well, that's all other issue.
They have minimum funds in their operating budget to cover the ongoing expenses.
All right.
Yeah.
You know,
Well,
the utilities and all that kind of stuff. They don't fund repairs through their operating budget, which I would consider repairs.
Yeah.
And
Yeah.
this, I want to make sure we all understand the things that Delegate Weibel, some of the things that Delegate Weibel is specifically referring to are maintenance items. Those are maintenance items. You know, if you don't.
So is there a definition of maintenance items versus capital improvement items in your bill?
There is a definition in here someplace, and Matthew, if you could find in here while we continue our discussion about the type of items that need to be funded in reserve study, I'd appreciate it, Matthew, while we continue our discussion.
And if I could add that a reserve analysis, somebody who has expertise in a reserve analysis will tell a community that shouldn't be in your reserve analysis. That should be in your operating budget.
That is correct.
That community might make a decision that we're not going to have an operating budget. We're going to specially assess on operating items. I don't know. I don't know enough about the rest of HOA and condo law to know whether that's a thing you can do, but it sounds like that's what they're doing for those types of expenses. But in terms of a reserve analysis, I just wanted to say that my experience has been their 30-year, but I Googled it and it does say 20 to 30 years. it's a 20 to 30 year period. So I don't know how they treat a 50-year expense. I don't know if they instead, they don't start scheduling for that right away and start scheduling it when it's 30 years out or not. But that's somebody with an expertise would know that. And that's part of the issue is that people running HOAs, I was the president for a while and would have no idea whether you spread that over 30 years or 50 years or what have you.
And if I could expand upon it, one point there just for a minute, Delegate Truss, I didn't mean to cut you off, because I know it's one of my rules that I don't like. The operating fund and the reserve study fund are to be held in two separate accounts. They are separate because you can't use maintenance money for the reserve study fund. Delegate Truss, I'm sorry, I didn't mean to cut you off.
Sorry, I'm done. Thank you.
All right, Matthew, if you could tell me where that language is, please, I'd appreciate it.
Sure. So again, with regard to cooperative housing corporations, if you look on page 2 of the bill, lines 3 through really 3 through 8, because it goes into some additional identification of the components. And as I had mentioned previously, this definition, a lot of the language is common from one common ownership community to the next. So I haven't found it yet for condominiums and homeowners associations, but that would be the active definition.
Thank you. Okay. Seeing no other questions from the subcommittee members, we're not going to go to some of the stakeholders. Mr. Enton, you had your hand up first, Mr. Enton. You're on mute.
Just to say that, we have suggested an amendment. The homeowners associations throughout the state of Maryland are so different from the condo associations. You're not talking about roofs. You're not talking about plumbing. It's a totally different ballgame. And in the vast majority of HOAs throughout the state, there are those homeowners associations. They're basically just, they're tracts of land that are subdivided into lots. And there are, there are not recreational facilities, there are not private roads. And all this exemption does is recognize that there isn't a difference between your typical HOA and your typical condo association. I, appreciate that Delegate Terrazzo was, the president of an HOA, and would be happy to work on language. But I don't think in the absence of these common components, whether what she was talking about or what we had listed, recreational amenities and private roads, it doesn't seem to me that there's a need to do a reserve study. And that's the purpose of the amendment.
Let me make sure I can understand completely. I'm looking now on page number 8, okay?
Right.
And I'm looking at page number 8, lines 20 through 22.
Right. Is that the language where the $10,000 is?
No.
Oh.
Page 8, lines 20 through 22 identify items that need to be put into reserve study. Structural, mechanical, electrical, and plumbing components and common areas that are responsibility of the homeowners association. So I'm guessing, because I don't have anything here in writing, I'm guessing that what your amendment is going to suggest is that the language in lines 20 through 22 would not identify structural, mechanical, electrical, and plumbing. You would just say recreational and roadways.
Right. We would go ahead. I think what our amendment does, and what we've amended is that if you look at the language on page 8 in lines 30 through 33, and then down into page 9, line 1, it says this is if you will, an exception. And what it says is this section applies only to a homeowners association that has responsibility under its declaration, and what last year you had, for which the total initial purchase installation cost is at least $10,000. And what we're suggesting was to replace that and to say that the and would say, and the HOA has recreational facilities and private roads.
But that to me, and I haven't seen the language yet, but to me, that would eliminate what is being discussed in lines 20 through 22, structural, mechanical.
Well, I think, so if I could respond, I think what you're going to find, you still have to do the reserve study, and you have to identify, you have to go out and have it. I think what you're going to find is that in the vast majority of HOAs, and I know Delegate Terraza says they had, I guess, I don't know if they had a swimming pool or what they had. They had a retaining wall. They had things to maintain. But the vast majority of them, why do you have to have a reserve study if you don't have any structural, mechanical, electrical, and plumbing component?
All right.
Okay,
Well,
we want to try to shift it to say you don't have to have the reserve study unless, and then come up with some exceptions that say if you have A, B, C, or D, then you do need to have the reserve study.
All right, I'm going to get back to Delegate Terraza in a minute, but right now I'm going to get Delegate Terraza and Delegate Healy, but I want to recognize some of the other participants outside of the committee for a moment, if the committee doesn't mind. Let me go to Tommy Tomset first, and then Ms. Strawn second. Mr. Tomset.
Yeah, thank you. Thank you, Mr. Chair. I appreciate this. And on behalf of CAI, I guess one of the concerns is this is almost like double dutch at this point. You're asking us to jump into this process, have reserve studies, and as Delegate Weibel pointed out, some of these things may be 20, 30 years in the future, and the bill assumes that we're starting from year one, whereas we may have people coming in and the AC unit may need to be replaced or the roof may need to be replaced in year 10, and years 1 through 40 haven't been funded to this point. And so the concern is the reserve study, there's going to be big swings in different communities. So some communities may be starting at point 1, their roof may be new, and they can prepare for that over the next 50 years. But the communities that are at year 40 on their roof have to make up that gap in the reserve study moving forward all at once. And so I'm hoping that you can point to some flexibility in the bill to say this isn't just going to be a big wallop all at once to some of these communities who may have deferred this up until this point because the law did not require it.
Well, Mr. Thompson, in your example, and I hate to keep going back to the car oil filter, in your example, that roof that you said you need to fund it in 4 years, and they don't put money in it for the next 4 years, at the end of that 4 years, they're going to come up with the entire amount, special assessment. So it's my opinion, it saves the common ownership community from having to pay those huge chunks of special assessment. And at this point, I'm still trying to grasp, and I don't want to put it this way on a personal level, I'm still trying to grasp why I'm wrong, and I don't see it yet. And I just don't see it.
I'm not necessarily saying you're wrong. I'm just saying that the impact is going to be different for each community because there are different points in the life cycle of the reserve study.
I agree.
And so I personally think that a special assessment unfortunately will occur in the case of the community association who may not have condos, who may not have, been up to speed and looking at their aging infrastructure and properly funding that. But then when this bill hits and it becomes law, they're going to have to make up that lost time, unfortunately, for them. Whereas I agree with you, there's other associations that have the foresight and have the leadership to have these things in reserves, and moving forward, it'll be easier for them. So I just think there's going to just be a disparity in some of those communities where they haven't thought about this up until now, and they're being asked to fund it immediately. And I'm hoping you just can point me to some flexibility that allows, less enforcement maybe in those situations on those communities.
And it sounds as if what you're suggesting but not saying is a phase-in period.
I think a phase-in would be helpful in the sense of because of the way the bill is written, you would need 100% of the reserves in your first fiscal cycle after the reserve study is completed. And then every 5 years you'll have a new reserve study. I think as this gets going, it'll be much easier for the community association to tease out that expectancy. But again, you're now everybody's starting at year one. They're starting. Some of these communities are 50 years old. They're way behind, and they may have very little in reserve. So yes, a phase-in of some sort would just kind of temper the blow that this law is going to have. It's going to have a meaningful impact to these communities. And so I think, so phase-in it would certainly be more helpful. And I just don't see that anywhere in the bill.
It is not in the bill on purpose, Mr. Thompson. Yeah, on purpose. If you're complete, I'll go to Ms. Strawn next.
Yes, sir. Thank you for the time.
Thank you, Mr. Chair. I just wanted to point out with respect to the amendment that the builders are seeking, we have received complaints about a community that is a homeowners association that's having serious problems because of their stormwater management pond, which would not fit into recreational facilities or roads. We have another homeowners association that we've received complaints about that is having serious problems with a retaining wall and their sidewalks, which are collapsing. So I just want to point that out that, this is not the full complement, as Delegate Terrassa pointed out, this is not the full complement of what a homeowners association faces when you just say recreation and roads. And because we're seeing other problems, I think those need to be considered as well. And that's why I would recommend not taking that amendment.
All right, let me go to Delegate Terrassa and then Delegate Healy.
Thank you so much for saying that, Ms. Strawn. And I just want to be clear about my experience here, because Mr. Anton seemed to boil down to being president of my 77 unit HOA, but I have a tremendous amount of experience in this field. I mean, not only was I president of my HOA, but I was on our village board, which was over quite a few HOAs. I was council member for 12 years and zoning board chair for many of those 12 years, and now delegate for 3.5 years. So I have dealt with many HOAs, and I was also sort of the go-to person on a lot of the HOA issues on the council. So I've had a lot of these HOAs issues come to me. I would really like to know which those HOAs are that don't have any of these bills that are looming in some ways, maybe the new ones, but they all have common property, and that common property often has stormwater issues over the years, especially with erosion, et cetera, has all sorts of what may end up with retaining wall issues, et cetera. So, I mean, we had to put a French drain in that never needed to happen in the first 15 years. I mean, there's all sorts of things that come up as a community is aging, and I have never seen them be in the smaller range, like in the $1,000 to $2,000 range.
Thank you, Delegate Terrassa. Delegate Healy.
Thank you very much. I've been listening carefully, and I understand what the discussion is. I do think that for Mr. Anton, that it's more about making exceptions and not about what your amendment seems to do is to reverse what is being requested in this bill. It's one thing to carve out an exception for a good reason. It's another to say everything except this exception doesn't need to be done. And I think that is just a question of how you phrase it. In other words, if you enumerate what is accepted from the bill, what you want not to be covered, and there's a good reason for those things, that makes more sense to me. That we want to have a catch-all bill that covers everything that needs to be covered and pull out the things that may not need to be covered, rather than say, we assume that if you don't have recreation or roof to fix or something like that, that everything else will be fine. And I don't think that's the point of this bill. I think the point of this bill is we need to make sure that everything is covered that needs to be covered. And if there are a few things that don't need to be covered, we can list those. I just think it's more of a drafting question than it is anything else. And I agree with all that has been said, but Delegate Holmes and Delegate Terrassa about the liability that can wait. I have talked to people where things were not done for 30 years and high rises where, you know, the tiles were falling off the side of the building and hitting people. So these things have to be, you have to look to the future. You have to maintain things and you have to have money available when things don't go right, in my opinion.
Thank you, Delegate Healy. Delegate Parrott, has your question been answered?
No, thank you, Mr. Chairman. No, I think Delegate Healy really brought up a good point that really part of what we are talking about is possibly making exceptions. Like I was the HOA co-president of my HOA, but we don't have that many things. Our total assets are probably under $20,000, like 2 monuments to come in, a couple lights, and that's it. The stormwater management pond is owned by the county. The open areas are owned by the county. So, and the road is the county. Like, it would not make sense at all for this community to have this huge expense. Maybe it's something like if they have assets of $100,000 or more. I don't know. I'm just throwing that number out. Maybe there's a different number that's better. But for this really small community, but we had a lot of houses, 181, but we didn't have a lot of assets. So it just didn't make sense for us to have to do that. It would cost a lot of money for nothing.
Thank you, Delegate Parrott. And I want to caution us from defining small as the number of units. And that, Delegate Parrott, you did not suggest that. I don't want you to say that you did. I want to caution us from defining small because some of you may have seen me on Channel 9 where I was with a 24-unit townhouse community with no reserve study, and their costs to repair the common elements are astronomical because it didn't have a reserve study done at any point. Let me go now to, I'm sorry, Delegate Parrott, are you complete? Okay, I didn't want to cut you off. Let me go now to Mr. Silverman and then to Mr. Hinton. Delegate Healy, I'm sorry, and then I'll go back to Delegate Healy. Okay, Mr. Silverman.
Thank you, Delegate Holmes. I just wanted to first, my name is Scott Silverman. I'm a community association attorney in Rockville. I've been doing this for over 25 years, representing community associations. I'm on the Maryland Legislative Action Committee, and I had the privilege of participating in Delegate Holmes' task force this year prior to the session where we worked on this specific issue. I wanted to make two comments. One, with regard to Mr. Enton's requested amendment, it is true that there are associations out there that have almost no capital improvement type items. In other words, they don't have public streets, they don't have recreational facilities, they don't have stormwater management facilities. There's really nothing to reserve for. And if that is the case, then I agree, and CAI agrees, that a reserve study expenditure is probably unnecessary. That's the first thing. The second thing is with regard to the phase-in, because we've had a lot of discussion, as Delegate Holmes knows, about the phase-in. I want to make a distinction between what a reserve study and reserve funding are trying to accomplish versus the catch-up maintenance problem that we're looking at. These are two different things. They're related, but they're two different things. Okay, if a community, like the one Delegate Holmes described, where they had no reserve study, they had massive infrastructure problems, they haven't been taking care of things. If that situation exists, they have an immediate problem. A reserve study is not going to solve the immediate maintenance problems. Those problems have to be dealt with today, now, and they're going to need the resources, the financial resources available to do that. And that's yet another discussion about where that money is going to come from if it can't come from the unit owners, because there's a lot of communities where hitting a unit owner with a $10,000 or more special assessment all at once, it's going to be a major problem because they don't have the money to pay it. So there's going to have to be resources out there for them to borrow the money or what have you to take care of those immediate problems. Once they get back on track, then to avoid that happening again, they're going to need a reserve study and reserve funding. But recognizing the burden, the financial burden that could put on them, it is, we think, reasonable to allow them a period to phase in up to 100% funding. And the reason we believe that is because myself and many other practitioners who have been confronting questions from our clients about compliance with the existing Montgomery County and Prince George's County legislation, the pushback that we've heard most is that there's a tremendous financial burden on individual owners trying to meet 100% of the reserve study recommended funding level in the very first year. So for those communities that can't do that, we believe that a phase-in is reasonable, and we think that 3 years is something that is not detrimental to the underlying goal of the statute, which is to ensure that the reserve studies and the reserve funding are in place, so that we don't have a Surfside type calamity in the future. So I just wanted to make that distinction, that we shouldn't allow ourselves to conflate the reserve study issue with immediate long neglected maintenance problems, because those problems need to be solved today. Thank you.
Thank you, Mr. Silverman. And I want to publicly thank you for participating in the task force that we've been meeting in since June, and the task force for meeting since June for at least 2 or 3 times per week since June. Thank you for your participation, Mr. Silverman, and Delegate Trassa as well. What I'm going to do next is I'm going to continue with the stakeholders. I'm going to go to Mr. Hinton and then Delegate Weibel and then Delegate Trassa. Mr. Hinton?
Yeah, thank you. Let me just say that, you know, I appreciate the discussion, and I would hope that we could work some language out that would recognize that there are differences between condominium associations and homeowners associations. Almost every condominium association is going to typically have common areas. It's going to have recreational amenities. They're going to have responsibilities for things that many HOAs do not have. And I recognize there may be some that do have them. So maybe the trick will be to come up with some language that recognizes that. You know, if there are no amenities, there are no common areas, there's no stormwater management. That's what I've heard so far, and retaining walls. You know, whatever it is, then why do you have to go out and spend money to hire a firm to tell you that you don't need a reserve?
Well, one of the things I want to caution us on, if you don't have specific items in your common ownership community, I would prefer that we had some evidence that those items are not part of your community. In other words, I can appreciate that, you know, you don't have a whole lot of expenditures for common areas in your community, but I do not want a board member who is a very well-respected professional, but not a professional in this scope of work, to write something up and say, we don't have anything in our common ownership community, therefore we shouldn't have to pay. I don't have that. Let me go to Mr. Weibel, Delegate Weibel, and then Delegate Trassa.
Yes, I thank you, Mr. Chairman. I just want to ask Ms. Strawn a question. So you said earlier in the discussion that your office has fielded complaints in this arena. Can you kind of give us an idea of how many complaints, what kind of complaints, what dollar amounts, what type of cases that you fielded in the past, how often you fielded them?
Well, what we get is people who are complaining because they've been given a special assessment of a large amount because of a particular problem.
Okay, so how many of those do you get a year?
Well, unfortunately, we can't do anything in most cases about the special assessment. So not everyone files once we talk to them. But we do get calls and complaints about that. And I would say that we get probably about 100 calls a year about people who are complaining about large special assessments. Some of those turn into complaints, like Sunset Island did, because that's what happened with Sunset Island is eventually they got a special assessment because of more problems with the association. And those were a couple $100,000 per person. So they go all the way up to that, and they go down to being more minimal amounts. But even at a $2,000 or $3,000 level, we sometimes get complaints from people that they got a $2,000 or $3,000 special assessment because for them, it's too much.
So actual complaints filed, that somebody follows through and files a formal complaint, how many of those you get a year?
I would have to guess. There isn't a way to run a report that would tell me that
Oh, there isn't.
specifically.
Oh,
And if I could interject, Delegate Weibel, for a community board member to make a special assessment against a lot owner or a unit owner, there's nothing illegal about that.
right.
And so the complaint to file for a special assessment is not illegal. You know, that's one of the things we're trying to circumvent. So the complaint going to the Attorney General's office about getting a special assessment, there's not much, and I'm not a lawyer, nor do I play one on TV, there's not much that they can do about it because it's not illegal.
Yeah, I was just trying to get a feel for how big the issue may be.
Sure. Thank you, sir. Delegate Terrassa?
Two quick things. One, in terms of this, I am very well aware of the differences between HOAs and condominium associations, but HOAs are set up by developers because there's common area. Like, I don't understand what, I would love to see your examples of HOAs that don't have any common area at all.
Okay.
And if
We'll be
have
happy to get back to you.
yeah, I would love to see that, because otherwise I don't know why you would why would you set up an HOA? What would the HOA do?
Let me
Get back to you. There may be restrictions on the use of the property. You can't have, things like that. We'll get back to you on that.
Okay. And then the second thing is, Mr. Silverman, I'm sympathetic to this idea that right away is really quick to fund the reserve, but I'm a little confused about how it works. So let's say like a reserve, and I'm just trying to figure it out in my mind how this would work. So let's say the reserve analysis, I'm going to use really low dollars just to make it easy to talk about. But let's say the reserve analysis says that each resident or has to put in $100 a year into the reserve, and we give them 3 years to get up to speed. Would that mean they have to pay $300 in the third year?
Mr. Silverman, if you're still there, I think what Mr. Silverman might be suggesting is a 3-year phase-in period, 80%, 90%, and then 100% the third year. Mr. Silverman, are you still on?
Yeah.
Okay, go ahead.
What Delegate Terrassa, what we're trying to do is, like, say, for example, the research study comes back and it says that in order to meet recommended funding levels, they have to fund the reserve account up to $100,000. They should have $100,000 in the reserve today, right now. And there's, I don't know, 20 units. So that's a substantial amount of money. What I'm saying is allow them 3 years to get up to the $100,000 balance, so that it's not so much of a burden financially. That's the suggestion, is that, in other words, that they what they would be required to contribute to get to $100,000 is only 80% in the first year, 90% the second year, 100% the third year, and then every year from then on, whatever the reserve study says they need to put away, that's what they have to put away at 100%. So it would be 100% for the future, but it's a gradual upward A more
But-
gradual.
But you would raise the amount that you'd have to pay after the third year, right? Because you would miss 3 years of you'd miss 3 years of payment.
Right. What they would have to do is the reserve specialist would have to recompute the schedule, the funding schedule, to take into account the 80%, 90%.
So all the payments after that would be higher?
Well, basically the 80 and 90, the 20% in the first year and the 10% in the second year would be amortized over the life of the reserve study,
Okay.
out 30
Okay.
years.
All right, thank you. I appreciate that.
Not a
Ms.
problem.
Strawn?
My pleasure.
Yes, just to let Delegate Terrassa know, there are actually HOAs that have no common elements. I, in fact, live in one.
Interesting. I did not know that.
Yes, but in that regard, because we have no common elements, there's nothing for a reserve study to do. But our HOA actually does a tremendous amount of work, even though we have no common elements. They do architectural guidelines. They do zoning issues that come up in the area around us. And so our HOA is extremely busy on for what we pay an extremely low HOA fee.
This is what I'm going to do, ladies and gentlemen. I don't see any additional questions. Those of you who have amendments or amendment suggestions, I'm going to ask that you get those amendment suggestions to me immediately so that I can get them put into a written format, and we will present them next week. All right. I want all of your suggestions submitted to me so that we can, or submit to someone. I want the amendments from the amendments office submitted, so we have your suggested amendments in writing, so we're not poking in the air and looking at what needs to take place next week. Sound like a good idea? Perfect. All right. Moving on to, and I've lost my place. The next bill is
117.
117. Matthew, you want to give us a brief discussion on 117?
Certainly. Okay, so this is a bill that authorizes a cooperative housing corporation to include in its governing documents a requirement for each member to maintain a certain insurance policy on the member's unit. There's also some notice requirements that would be included for both cooperative housing and condominium communities. The provision to include in the bylaws a requirement for each that the owners provide, the members in a cooperative or the unit owners in a condominium provide evidence of insurance coverage to the governing body on request.
Okay.
And so with this, I know that there were some changes that the sponsor had requested, and I believe groups that he was working with to incorporate those changes, just make sure the intent was properly covered. Believe that individual might have been Mr. Silverman, who is on the call. So it might be best to start with perhaps Mr. Silverman giving an explanation of those.
Okay. Are you complete, Matthew?
Yes, because we don't have an amendment from the sponsor, so I'm not sure exactly what that amendment would do. I just know one's incoming.
Mr. Silverman?
Yeah, my understanding is this legislation is being driven by a specific concern coming out of Leisure World. There's a cooperative in Leisure World where the building contains aluminum wiring.
Aluminum wiring.
As a result, there have been losses at the condominium that have resulted in the imposition of a $50,000 deductible on their casualty insurance policy. And the coverage itself for that building is layered. In other words, there is a carrier that takes the first so many dollars of a loss, and then another carrier takes the next threshold, and so on to make up the full amount of coverage on the building. And that was done in order to keep the premiums affordable. The cooperative wanted originally, when this first came out, wanted to impose its entire $50,000 deductible on a specific cooperative member as a result of a determination that that member's conduct had contributed or caused the loss. When the legislation was ultimately written, that was back down to $10,000, which matches the deductible chargeback in section of 11-114 of the Condominium Act, which was raised, I believe, 2 years ago. A couple problems. One is, in a cooperative, as many of you may know, the individual member does not own any real property. They have a leasehold interest in the unit by virtue of what they call a proprietary lease. And they have a share, they own a share in the cooperative corporation, which is personal property, not real property. In addition, in most cases, the cooperative corporation is responsible for maintenance, repair, and replacement in the building. The member has very limited maintenance, repair, and replacement responsibilities. So the concern that we had at CAI was, are you requiring a member to insure something, one, that they don't own, and two, against a peril that they may not be able to prevent because they don't have the authority to maintain the thing that is believed to cause the loss. So the question is, what are you requiring them to insure? And it's been, I've been advised that although the ownerships of co-ops and condos are very different, in fact, the carriers do write what we call HO6 policies for co-op members. And the HO6 is a shorthand for what an individual condo owner obtains to cover their personal property and any improvements or betterments made to their unit, which are not covered by the master policy, the condominium's master policy. So the co-op member can obtain an HO6 policy, but then what is it intending to insure? In other words, are we talking, and I believe the discussion eventually came about that, and Karen can fill in the blank maybe a little bit more because she was involved in this, that we were focusing on liability. In other words, insuring the member in case of a loss caused by their negligence or intentional act. Well, it wouldn't be intentional, but negligence. It would be their fault. But we were talking about liability, but not necessarily property loss. So I guess my concern is if we can word the statute, and we're working with Delegate Stewart on this, it's kind of a process in evolution. If we can word the statute in such a way that we can make the owner responsible for ensuring a loss that's related to something that they're required to maintain, would everybody be on board with a statute that requires insurance in that limited situation? In other words, property insurance. So we say, cooperative member, you are responsible for obtaining an HO6 policy that covers a property loss if the loss originates in your unit, and the term unit is defined in the Co-op Act. It is already a defined term, and it's defined as that space which the member occupies. So if it arises in your unit or from your unit, and it is due to a component, the failure or problem of a component that you are responsible for maintaining, then I don't think that we would have a problem with requiring the member to obtain insurance in that limited circumstance. And also, of course, for liability, such as somebody slips and falls in their unit or something of that nature, which is what condo owners have, and for personal property, things like that. So I guess what I'm trying to say is we want to try and bring the co-op situation in line with the condo as much as possible while recognizing the fundamental ownership difference and maintenance responsibility differences between the two forms of living, of community association living.
Thanks.
I hope I didn't confuse things too much there, but.
Thanks, Scott. I can tell you, this conversation that you just had right now has taken me all the way back to my certification for community association management exam. Holy smoke. The bottom line here, however, is that the sponsor is going to be having amendments prepared with your guidance. Is that correct?
That's correct. Yes.
We look forward to seeing those. Delegate Healy.
Yes, I'm sure you know that I'm going to ask about Greenbelt. The co-op in Greenbelt. GHI. And because you're not dealing just with Leisure World in this legislation, you're going statewide on co-op law.
Totally agree. Totally agree.
I really, if you're going to be working with the sponsor on amendments, I really would truly appreciate if you would reach out to the leadership at the GHI co-op, which has 1,500 units and has been around since the 1930s. And
founded by Eleanor Roosevelt.
That's correct. And so that because I am not going to support anything having to do with condos unless I am confident that it will not have an adverse effect on that community in Greenbelt.
Thank you, Delegate Healy.
Thank you.
Thank you, Delegate Healy. Lisa Harris Jones.
Chair, I just want to quickly let everyone know, because I got a text from a wonderful delegate from District 13. So Scott is a member of CAI, so he's speaking for CAI. And we are keeping Delegate Healy's concern in mind as we draft the amendments, and we'll reach out.
Well, Lisa Harris Jones, I also am a member of CAI. I just got to notice that my dues are due as well. So there. All right, we will wait for the amendments coming in from the sponsor, and we're going to now move to the final bill of today, and that will be HB 140 in reference to governing bodies and annual meetings. Matthew, can you give us a brief discussion on what's happening here?
Certainly. So this bill in its current form is unchanged from the bill that the committee passed last year and that was passed by the House. The vote in the committee was 20-3, and it passed the House on third reader in this form by a vote of 101-31. There are a couple of amendments being considered. I can go into a general overview of what the bill does as well, if that would help.
Please,
as a reminder.
Please,
okay,
please.
So the bill would require the board of directors or developer of a condominium, board of directors, sorry, it would require the board of directors or the developer of a condominium or the board of directors or the declarant of an HOA to convene a meeting at least twice a year at which the agenda is open to any matter relating to the condominium or HOA. Additionally, at each meeting after control of the condominium or HOA has been transferred to the unit or lot owners, non-board members would be given the right to speak. Now, however, if the agenda is limited to specific topics, the comments that can be made might be limited to those topics. There's also the addition of a non-developer, non-declarant affiliated member to a board if one is established once a certain percentage of ownership by the public is reached in both a condominium or an HOA. And then there's provisions related to books and record keeping from condominiums and HOAs as well.
Thank you, Matthew. I do know that there is has been some discussion in reference to this bill, and the discussion in reference to this bill in terms of some suggested amendments by some of the stakeholders is relevant to the portion of the bill about the bonds. And I'm scrolling through the bonds. The way the bill is written, and I'm going from memory here, I can't find the exact location. The way the bill is written now, it states that the bond, it states that the bond holder, I believe, someone has to notify the lot owners in terms of the bonding requirements and the release of the bond. Keep in mind, ladies and gentlemen, that the bond is a specific instrument only between the developer, the declarant, and the local jurisdiction. But there is some concern about the bond information here. Delegate Healy, is your hand up from this discussion or from a previous discussion?
That was the previous one. I'm sorry.
Thank you. It's okay. So I do know that Mr. Inton had talked about some amendments, and after Mr. Inton, I'm going to pick on Ms. Strawn to discuss the proposed amendment from Mr. Inton.
Let's see. I'm sure I'm not.
You're on. Go ahead. We can hear you.
Okay. Yeah, I think, our concern is, quite frankly, we don't really think that it's necessary or appropriate for parties for persons that have no interest in the bond whatsoever. The Delegate Holmes stated the bond runs in favor of the municipality or the town or the county. And to now require by statute that you furnish all this information to people that don't have an interest in it, we think is not a good idea. We think it's counterproductive. We think it muddies the border. We think it creates almost an impression that they do have an interest in it. It's up to the beneficiary of the bond, the person that the bond is in favor of, to go ahead and they're the ones that have an interest in it. Just don't think it's appropriate or see what the purpose of it is, quite frankly.
Thank you, Mr. Inton. Ms. Strawn?
Thank you, Mr. Chair. The governmental entity and the declarant or the developer are the ones that the bond is between. So what happens is you're working in an association and you're building roads in an association. And when the declarant or the developer says the roads are done, they ask for a release of the bond from the government entity. Well, the government entity doesn't always go out and check to see if this happened and it's all taken care of. They just simply say, oh, it's done. Okay, great. And they release the bond. The problem is it's the third parties to this, which is the people who live in the community are the ones that know whether or not this is taken care of or not, know whether or not there's additional problems concerning the bond, and know whether or not they need to notify the government agency that the roads are not complete if it's a roads bond. So it's important that they get notification before the bond gets released so they can at least notify the government agency that it's not done. And I'm a little confused as to why this is coming up as an issue this year, because we went through this last year and agreed on language and everyone was in agreement with it, including Mr. Enton. So I'm concerned as to why it would come up again to change the language and make it so that the people who live in the community don't have a right to know that the bond's going to be released.
Once again, I think if people have a concern about it, they can certainly go to their public official. If there are infrastructure things that have been done, I mean, that's typical. Storm management, sewer, water. Those are the things that the county wants to make sure that are properly done, and that's why the bond is put up. And if they have a concern, and they can reach out to the political subdivision and raise that concern. Nothing prohibits them from doing that. We just don't see the purpose of this language when they don't have an interest in the bond.
Thank you. Thank you, Mr. Inton and Ms. Strawn. Let me go now to Delegate Terrassa.
I 100% agree with Ms. Strawn. That is absolutely what happens. I know, it's shocking. But I will tell you, this comes up all the time. This came up all the time when I was on the county council. And there's no way for residents to know when, I mean, I guess they could call and trace down and that the bonds even exist, never mind that they're about to be released. So that they wouldn't know when the deadline is for the road to be completed. They wouldn't know when the deadline for other things are, that there is a bond, that it's about to be released. This just gives them that information so they can say, wait a minute, that this hasn't been completed. It makes perfect sense to me to have it in this.
Ms. Lisa Harris Jones, I saw your hand up. Are you still have a question
Yeah.
or?
I mean, Ms. Strawn actually pointed this out, but this is a bill that we spent a lot of time with last year. And I brought in some experts from CAI and we met and we discussed, amendments and worked it out. And I'm just surprised that, that there's concern from those that were a part of those discussions and negotiations. Now coming back again, I guess at another bite at the apple on something that was negotiated, but I agree with Ms. Strawn on why the bill is fine the way that it is, her explanation on why we need the language in there concerning the bond. But I'm just kind of baffled by, the fact that we're trying to negotiate it, something that was agreed upon last year. I can make my notes.
I appreciate it. What we're going to do, that is the last bill for our discussion this afternoon, ladies and gentlemen. And as I indicated previously, there are amendments or desired amendments, then I'd like to have those in written format prior to next week so we can discuss the proposed amendments in next week's meetings. And I've recognized now what the glitch was in me getting started with this meeting. And now that I've recognized the glitch, it will not happen again. Guarantee. Okay. Mr. Wyville.
So when you say amendments, you want formal amendments through the amendments office, or you just want an amendment submitted to you in writing by the members?
What do you suggest, Mr. Wyville? What do you suggest? And I'd like to make it and I'm asking this because I'm asking it not just of you, but of everyone. I want to make this as smooth as possible and as clear as possible. Is it possible, do you think, for us to have just plain written amendments, not necessarily through the amendments office, to make it as smooth as possible? Do you think?
Well, I mean, I think a formal amendment, it's clearer exactly what the member might be asking for, but at the same regard, it might be insulting to the bill sponsor, AKA the subcommittee chair, if somebody submits an amendment that they're not particularly receptive to.
I see what you're saying. I do not want anyone to think that the subcommittee chair is going to be insulted. I recognize the debate that we're having, and I want to see us discuss these out in the open. I won't be offended at all.
So if it's a formal amendment, it's easier to look at it and say yay or nay. I think
that's exactly what I'm looking for. Yeah,
okay.
I will not be offended. I know I'm not always right. There may be opportunities to fine tune something. I just want to make sure that we as a subcommittee do what's best for the people that we serve. And I think the only way to do that, unless someone has a different idea, I think the only way to do that is have something in writing.
All right, thank you. Mr.
Hinton?
I just want to be clear, Mr. Chairman, that, of course, we have no power to go to legislative services and get an amendment drafted. We can do our best. If we submit those, in a timely fashion, and usually they're not too poorly drafted, hopefully, and then you want to adopt them. But, we don't have a mechanism unless one of the members would request them to get them drafted by DLS.
And that's why I'm suggesting that you got an amendment, you, Mr. Silverman, or send it to me. I'll send it to the amendments office.
Okay.
All right. Now, I'm not saying
that you support it. You're just going to send it. I get it.
That's exactly correct. I want to make sure you're clear.
I'll give the delegate to Rasa. So I know she'll.
All right. Anything else, ladies and gentlemen? Fantastic. And I appreciate your patience with me at the very beginning, but I've understood what my glitch was and it will not happen again. Thank you so very much for your participation. Hang on, Matthew. Go ahead, Matthew.
So next week, being what it is, and there not being a hearing, there is the opportunity potentially to do an out of cycle meeting, which might give more time for discussion of bills. So, sorry,
Yes.
Delegate
yes.
Holmes, if you would like to speak about that, we might be able to schedule that. And I just wanted to kind of alert members now that if that were to happen, there might be an out of cycle meeting.
Yes.
And just to be on the lookout.
And thank you, Matthew, for that point. In terms of next week, we may have a subcommittee meeting on Tuesday and Wednesday.
Wow.
I know you all just cannot get enough of me. I know it.
Can't wait, Mr. Chairman.
I know you can't. Stand by. So thank you, ladies and gentlemen. I appreciate your time. And I really appreciate the discussion. As you all know, this stuff is near and dear to my heart. So we'll have at least one meeting next week, perhaps two, Tuesdays and Wednesdays. Send me amendments so we can look at these things in writing, please. Have a very good day. Thank you so very much. Take care.